I hope you can all hear me. My name is Helen Seagrave. I'm the Community Energy Manager at Electricity Northwest, and I run this series of Community Connect events, which is part of our support for the community energy sector in the Northwest. I'm going to talk a little bit more about what we do in a minute, but for now I'd just like to introduce the rest of the team and go through the agenda and some housekeeping. There we go. So the agenda this morning is an introduction and a welcome from me. We've then got Kate Aldridge from Greater Manchester Community Renewables, who will talk a little bit about the community energy perspective of this issue. Greater Manchester Community Renewables have installed 9 PV schemes, predominantly on school roofs across Greater Manchester, so therefore have a great deal of first-hand experience about what it takes to make these schemes work and some of the difficulties involved with doing that. Kate's section will set the scene for Justin, who is from the solicitors Stephen Scone, who have got a lot of experience in supporting community renewables, and they specialise in helping groups in this area, and he's very kindly agreed to share his experience today. So just a little bit of introduction to Electricity Northwest and our community and local energy strategy. We have developed a strategy based on feedback from stakeholders to support the development of our relationship and delivery of services to the sector in our region. So the top 3 areas where people said that they would had issues is where we focused our response, and this event is part of a series of events under our Community Connects banner, where we aim to put on events that are useful and engaging for this sector to help address some of the issues and barriers that they're facing, but also so that these events act as a forum for us to engage, to get to know the sector better. Obviously, our original plan was to run this event in person pretty much on the last Friday before lockdown, which is why we had to postpone. I'm very grateful to the speakers that we can run it again as a webinar, and I'd just like to say that if anybody wants to get in touch with us following this event or has any inquiries that can't be answered through the webinar, then you can always get in touch with us via our website, and I've got some contact details at the end. So the reason we're focusing on licenses or leases for what's the best option for community energy is it's one of the issues that was highlighted to us by through the stakeholder engagement. So I'm very pleased that we're able to respond, and I'm also very pleased and grateful that Kate and Justin have agreed to take part today. So and as you can see from the slide that shows a little bit of the state of the sector in our region, which is taken from this year's State of the Sector report. It shows the location of community-owned generation across our patch, the size of the sector in the terms of the number of groups we've got. And last year there was 7 community-owned generation schemes developed across our region, and 6 of them were roof-mounted PV. So it's a very pertinent issue that we're talking about today. But I think that's enough about us for now, and I will now introduce Kate from Greater Manchester Community Renewables to talk and set the scene for us. Thank you very much.
Thanks, Helen. So I'm Kate Aldridge from Greater Manchester Community Renewables. We started in 2015, and as Helen said, since then we've installed solar arrays on 9 sites, which totals 350 kilowatt peak. And we're obviously in a time of climate crisis, and we need to reduce carbon emissions urgently. And so we want to try and do more faster and scale up. So the reasons that I'm interested in this topic of leases or licenses is that I understand that some community energy organisations who have many more sites than us, and I can see Mike's on the call from Schools Energy Co-op, I know that they use licenses, and so I know that they also have lots of sites, and so can bear the risk or spread the cost if something happens at one of them, a lot more than if you have fewer sites. I also like the idea of signing something at the beginning before the development fees and having it all subject to feasibility checks, because we have had schools pull out after we've spent money on feasibility, basically. So I'm interested to explore the costs and benefits and risks around using licenses and what is the difference between leases. So from my perspective, I'm just going to talk for 10 minutes about GMCR's business model, if you're not familiar with it, what we've done in the past on legal arrangements and the sort of questions that I've got. So GMCR raises capital through community shares. Members are offered between 2.5% and 4% annual share interest as in return on that investment and the capital back after 20 years, if not before. We spend the vast majority of that capital installing the solar panels on the school roofs. The panels then generate clean energy, which the school can use, and we sell that electricity to the school at a 25% discount to what they pay their main supplier. And anything the school doesn't use is exported to the grid. So over the 20-year period, they produce enough income to pay for operational costs, the share interest for the members, and the capital repayment back to the members. And after those items, the profits go to a community fund. And so for our model to work, we need to be able to demonstrate that we'll generate enough income to meet these expenses and pay back the investor capital. So we do need the panels to be generating for the full 20 years. So what have we done before in terms of legal arrangements? We have previously signed exclusivity agreements with schools, well, with the local authority, should I be clear, which is the landlord, the owner of the buildings, which means that we've got an exclusive right to negotiate a lease of the roof airspace for a fixed period. I'd question whether that was more trouble than it was worth in terms of the time it took to get it signed, but I like the idea that they have to sign something before we start spending money on feasibility checks. We've never done a kind of agreement for lease or anything like that, but we do legal searches, sort of due diligence, as part of our feasibility checks. When we did our first lease in 2016, we started with a template. The local authority also wanted to do a heads of terms, but since we agreed that first lease with that first local authority, we've then taken that lease back to them again, but also to another local authority and said, this is one we've agreed before. Do we really need to go over and do a whole new one? So for all of our sites, we've got a lease signed with the local authority and then a separate electricity supply agreement with the school, which is the occupier and the one that's actually buying the electricity at the 25% discount. So under I've already mentioned they get 25% off. So I also thought I'd mention the context of the for legal agreements post feed-in tariff, because without the FIT, it's more important than ever that we have an on-site purchaser for as much as our electricity as possible over the lifetime of the project, because we get a much higher price by selling it to the school than we do from exporting it to the grid. And then there's also the point that even when there's a lease in place, the community energy group still bears the risk of the school closing, because we then lose out on that higher on-site usage price, and that has always been the case. So the lease does provide protection for GMCR because we know we have the right to be there for 20 years. And so my questions are around, in terms of a licence, is it easier to agree? And why is that? I understand from a local authority's perspective that they're thinking they're having to make a 20-year commitment to let us use that space, but they can't see into the future and they don't know what might happen in 20 years and what they might want to do with their land and buildings in that time. And also with a lease, I know that we have it noted on the land registry. So what is the benefit of that? Also, if the school or the local authority wants to break a licence, would we get compensation? There's also the practical side of it, like how much does it cost to negotiate these agreements and how long does it take? And I also know there's a practice of paying the other side's legal costs in some cases, which I really don't like doing because I just don't see what their incentive is to stop arguing at any point. And I'm volunteering all the time. And so any extra money we pay out is coming from the Community Benefit Fund. So I'm interested to know about what's normal there. And also, just if there's other things, like if we wanted to borrow money, does it matter if you've got a lease or a license? And if there's any difference in the key terms that you negotiate about, like we often discuss who will be responsible for the costs if the roof needs repairing and we actually have to pay our installer to go remove the panels, store them somewhere and then put them back. And my final point is about post-fit, is the changes that we could make to documentation now that we aren't tied to one particular site or MPAN that could make it easier or give more comfort to the other party that we're signing up with. I know that was a huge list of questions, but I have sent them to Justin in advance. So hopefully, I'm really looking forward to hearing what Justin's got to say and thanking him for helping us all out with this issue, which is a complex one. Thanks.
Thanks, Kate. I think you've set the issue and set the scene quite very nicely there, just particularly in how complex and involved it can be. So now I'll hand over to Justin, but just before I do, can I just remind people to keep their videos off because it helps with the settings from this side. Thank you very much if you're not speaking. Yes, and now I shall hand over to Justin, who can hopefully provide some answers or at least a bit of clarity on the issues that we need to consider. So thank you very much, Justin.
Thanks, Helen, and thanks also to Kate. Hopefully I'll remember some of those questions, and Kate did send them to me in advance, so I will hopefully cover those. Hope you're all well. Good morning. I'm Justin Butt, a partner in the energy team at Scone. I've got around about 8 years experience now dealing solely in relation to energy matters, acting on behalf of developers, landowners, funders and community benefit societies, which is something I've been doing for many years. You'll see I provide advice in respect to the technologies listed on screen. So a lot of what I see in the community energy sector is the rooftop solar, but I've done a ground mounted solar, wind and hydro, and tend to be more the community energy owned aspects at the moment. So a little bit of information about my firm, which is on the next slide. That's enough about me. There we are. Oh, that's it. Scone, you may not have heard of them because we're based predominantly down in the southwest. However, we won UK Law Firm of the Year in 2019. We're number 44 in the Sunday Times Best Companies to Work For, so hopefully the staff are relatively happy. I won't bore you with the rest, but the main point to note there is Sonia Bedford, who started the energy team and heads it up. She was awarded an MBE for her outstanding efforts in respect to the community energy sector. So hopefully you can see that myself, the energy team and my firm have a key interest in the community energy sector, and we're doing everything we can to try and champion it and try and get it moving forward. So on to the main event then. Why might you need a lease or a license? Sorry if I'm teaching anyone to suck eggs and if you're legally minded, but I'm conscious there may be people here on this conference call that don't have the requisite knowledge. So a lease and a license are both types of contractual agreements between the landlord or licensor and the tenant or licensee. The contract will set out the terms that the landlord and tenant must adhere to and that bind both parties, and so that's very important. Leases and license, ultimately what do? They grant permission for someone to use someone else's land or property for a specific period of time. Now that could be a long period of time. We've been talking about 20 years, but eventually that contract will terminate. A lease or license can be used to protect an investment into property or, an expensive asset. So for example, some of the rooftop solar arrays that my clients have installed, we've been looking at around about £100,000 mark. So not an insurmountable amount of money, and particularly where it's, a share offer, you're protecting investors' money. So it's very important that you have some form of written contractual agreement. So I've put a little note there, gentleman's agreement is never enough, that old handshake cliche. an example of this, and it just so happens it's very recent. I was walking around a golf course with a friend recently, typical lawyer playing golf, and he said to me, I lent my aunt £250,000 to pay off her mortgage. Now, who has £250,000 lying around? Not me, probably not most of us, but he had just come off of being captain on yachting, and he's now an accountant, and so he lent it to his aunt. Well, his aunt, being a family member, she's now refused to acknowledge that that is a loan and it was a gift. And I said to him, have you got anything in writing, anything which evidences this? And he said no. And I have seen, unfortunately, community energy groups who have entered into verbal agreements with a property owner, installed an asset only for the property owner to say, well, there's no agreement between us. And that really does become a bit of a nightmare to try and pick apart. So ultimately, what is a lease? Well, it's a relationship that operates between the landlord and tenant. And a lease is a right granted by the landlord to the tenant for exclusive possession of the property. And that's something I'll come back on a little bit later, for a certain term in consideration of the rent or the fee laid out in that lease agreement. So Kate alluded to it earlier, a lease creates an interest in land, which is very different from a license, which is just a personal contract between the licensor and the licensee. And I'll touch upon that a little bit later. A lease can be transferred or assigned to another party, and if it's registered on the title to the property, then it's binding on any new owner of the property. Now, this is where a license falls down, in that it does not bind successors in title. And again, I will pick up on that theme a little bit later. A lease is not revocable, so you can't just bring it to an end unless there are conditions set out in the agreement. So there might be, for example, a redevelopment clause if the property is to be redeveloped, or there might be a landlord break clause. But otherwise, it's quite difficult for a landlord to bring a lease to an end. So in my view, a lease offers far more protection for a renewable energy project. And as a lawyer, we always think worst case scenario. So I would always be suggesting to you your start point is a lease. A little analogy for you, and perhaps it's a little bit silly, but if you've just had a baby and you're about to buy a car, would you buy a car that had a 5-star rating or a 3-star rating to protect your new asset? Now, I know that's a bit far-fetched, but think of that in your solar asset, and how does that sit? So conversely, what is a license? Apologies for the graphics, I was struggling to find anything for a license, so I put old James Bond up there. So a license is simply a permission for a licensee to do something on a licensor's property, and the permission prevents the permission given to the licensee prevents it being considered a trespass, because if you go onto a third party's land without authorization, you are trespassing. So a license is by definition not a lease, it's a personal right or permission, and it doesn't offer any security from a property perspective. A license entitling the licensee to use the land, it will be for a specific purpose authorised by the licence, and doesn't create an interest in land, as I've said. A licensee's occupation is therefore precarious. If that landlord sells the property, even if it's to a group company, the licence will end. Now, the licensee may have a right of action against the licensor or the property owner for breach of contract, but that very much depends on what compensation provisions you've put in the licence for when it terminates. And again, I'll pick up on that theme a little bit later. Now, just as with a lease, same with a licence, if someone's breached the terms of the agreement and they do not remedy that breach, you will need to go through a court process and incur fees. So very similar process for both a lease and a license. So the distinguishing feature of a lease as opposed to a license is the exclusive possession of the property. The hallmarks of what the courts consider the lease are set down in the 1985 case of Street v. Mountford. I won't bore you with it, but ultimately it said, if the agreement satisfies all the requirements of a tenancy, then the agreement produced a tenancy, and the parties cannot alter the effect of the agreement by insisting that it only created a license. So just something worth noting. So I hope I've sort of stressed the importance of exclusive possession and control. And so community interest groups I have found have put in place agreements and said, oh, it's a license, when in actual fact it's a lease, and that does cause problems. So there are two crucial distinctions between a license or a lease, or tenancy is another word for it, and they are exclusive possession and control. So a tenant in a lease can exclude all others, including the landlord, from the property, and that's very important. On the other hand, a license does not grant tenant the full control of the property. A license is merely a right to occupy, and it doesn't give the tenant the right to exclude the landlord. In fact, the landlord should ensure that this is never the case, otherwise a tenancy could be created by default, and I will explain why that's a problem. So the question I'm always asked is, will labelling an agreement a license make it a license? In a word, no. The fact is that if an agreement purports to be a license, that does not mean it will necessarily be construed as a license. The parties ultimately cannot turn what in reality is a tenancy into a license by calling it a license. And I hope I've stressed that point enough. Even though a document is labelled a license, case law illustrates that the courts will look beyond that, the label given to it and the substance. The terms of the agreement are not irrelevant though, and the court will analyse what those terms are and the obligations contained in the agreement. So if the document has any of the following characteristics, this may indicate that a license is not in fact a license and it's in fact a lease. So has exclusive possession been granted? Arguably with community energy groups, of a roof space for or the airspace above the roof for a lease, ultimately there would be exclusive possession, because you wouldn't want the landlord up on the roof doing anything to the rooftops, causing any solar shading or interference. So generally, I would say that there was a tendency there. Is it for a fixed term? Well, yes, we've been talking about 20-year terms. And does it reserve a rent? Now, often these types of leases will include a peppercorn rent for a renewable energy asset. So back in the day, people used to trade peppercorns. It was actually quite a good thing to have in the olden days. These days, not so much. You would prefer to have some money, but the way that the landlord benefits is from the savings on the energy bill, which Kate has alluded to earlier. Now, landlords have tried to come up with lots of creative ways to avoid this exclusive possession point, such as including a provision to say that the tenant cannot use the property for a given period each day. The courts just instantly saw past that. So whilst that may be seen as an indication that there's no exclusive possession, you've got to look at the substance rather than the form. So why is the distinction so important? Ultimately, it revolves around the Landlord and Tenant 1954 Act. And very simply, if the license is entered into and then it's considered a tenancy, the landlord is going to have a lot of difficulty in trying to remove the tenant at the end of 20 years, because the tenant will have rights that are enshrined in the 1954 Act, and the landlord can only get it back for specific purposes and has to go through a court process. So it's really, really important from the landlord's point of view, and I appreciate everyone here would want to be the tenant or the licensee, but this is why you might meet some resistance in the grant of licenses. Local authorities that I've dealt with do not like granting licenses because they fear that it will be considered a tenancy and they will not have gone through the 1954 Act security of tenure process. And that process, very simply, is a notice is provided by the landlord to the tenants that says you have no automatic right to remain on the property at the end of the lease term or the license term, and the tenant will go away and swear a statutory declaration in front of an independent solicitor to say, I've had my notice, I understand the terms of the notice, and at the end of 20 years, I'll get off the property. So that's a process that needs to be built in. And of course, if it isn't built in at the outset and you enter into a license and then it becomes a lease, the landlord's going to become unstuck. So, advantages of a license. Well, you can, just like with a lease, include the circumstances in which a party may terminate or determine the lease, the license, and this will depend on what the terms of the license say. So, for example, the licenses I've been involved in and drafted, we've included buyout clauses. So we touched upon it earlier, the fact that a lease would bind the property, so any incoming owner would be subject to the terms of that lease. A license, if the landlord were to sell the property, wouldn't apply to the new owner. So in that instance, you would either want the landlord, before they've transferred the license, to have got the incoming owner to grant you a new license for the remaining term, or the landlord buy out the cost of the equipment and perhaps some compensation for loss of income for the remaining term of the license. Now, this is a moot point, and this is most definitely one of the key important clauses you will need to agree in advance of whether you go for a license or go for a lease. Because if the landlord turns around to you and says, well, I'm not compensating you if I sell the property, I need to be able to sell the property without your solar array there, and I'm not compensating you, you know straight away a license isn't going to be fit for purpose. Now, he might say, well, yes, okay, I will get the incoming owner to enter into a license, but that's just a contractual obligation. You would still have to go through the court system for specific performance to get them to ensure that happened. And if the new owner refused to do so, you would need to build in indemnity provisions that said that the outgoing landlord would indemnify you because they haven't transferred that license. So really, really key to make sure the terms of your license are on point. So costs. Yes, costs. A license is ultimately more straightforward. It's about 16 odd pages. A lease is about 30 pages, and that doesn't include the power purchase agreement, and that's the terms upon which the electricity is sold to the landlord and purchased by the landlord. A lease typically doesn't include power purchase agreement terms, and ultimately, I would say licenses do. But it does vary. There are lots of different forms. Sadly, I would say it takes about the same amount of time to negotiate a license as it does a lease. So whilst the cost might be cheaper, I think the time it takes, and having done over 100 community sites now, I would say they are broadly the same. So a license can also potentially avoid restrictions on the title. Kate alluded to the fact that you would need to do some due diligence on the property, and the title to the property is one of those things. And sometimes you will see restrictions on the title that say no disposition without the consent of so-and-so in respect of clause blob of an agreement. Now, on the whole, a disposition would definitely apply to a lease. So it's just a word for someone disposing of the property. So transfer, sell, mortgage, a lease. A license isn't always caught, but sometimes it is. Now, an example where licenses have been used, and similar to what Kate had alluded to earlier, is in order to avoid the Secretary of State for Education consent on schools. So that is a cumbersome process. If you haven't been through it already, it takes around about 12 months. There is a very simple form to fill out, but it just takes the Secretary of State ages to respond, and they often respond with many questions to make sure that it is a benefit for the school. So granting these licenses does get around that. Now, there is, of course, the risk that the Secretary of State does latterly look at a license and say, actually, hang on a minute, this is a disposition, and there's an argument later down the line, but we'll have to resolve that as and when it comes up. There are other restrictions on the title. For example, the title may be subject to a mortgage, just the same as perhaps your home is subject to a mortgage. That often says that you cannot dispose of the property without the consent of the bank. And more often than not, the mortgage conditions do preclude the grant of a license. So you have to check the document out of which that restriction arises to ensure that you can comply with it, and that the grant of a license isn't going to put the landlord in breach. So number 4, stamp duty land tax implications. Well, on the grant of a lease, generally stamp duty land tax is payable. However, there are thresholds that need to be met. More often than not, for rooftop solar, if we're talking, 5, 10, 15 kilowatt arrays, generally no SDLT is payable because it's under the threshold, and that's worked out on the savings that the landlord makes on their electricity bill, because that's the consideration that the landlord gets for the grant of that lease. Licenses are exempt and they're outside the scope of SDLT, so another tick in the box for a license. The 5th point, so an arrangement which properly constitutes a license. So remembering what I was saying about before, it's not just called a license, but actually a lease. But if it actually is a license, that's outside of the landlord and tenant Act 1954. So the licensee would have no security of tenure. So we don't have to serve that notice and swear the statutory declaration. It's just outside of those rules. So the disadvantages of a license. Well, despite the document being a license, I don't want to labour the point, but if exclusive possession is in fact granted, there's a risk that that arrangement will be considered a lease. Now, if there are several issues here, one I've already alluded to is the fact that some landlords won't grant a license because they fear it becoming a lease and then the 1954 Act security of tenure provisions applying. So that's instantly a cross against a license. The second is, if you do go down the route then of having an argument between is it a license, is it a lease with a landlord and what provisions apply, you're going to incur costs again later on. So it's really, really important to make sure whatever form of document you use and the terms on which it is drafted, it is either a license or a lease. An occupier or a licensee doesn't generally have the same control over the property as you would have if you were a tenant under a lease, because remembering a tenant under a lease can exclude the landlord from the property. The situation's a little more complicated in the cases of licenses because they are personal interests and don't create any proprietary interest in land. So again, the lease trumps the license here. A licensee's occupation is precarious, as I've already alluded to. If the landlord sells the property, even to a group company, the license will end. Although you will have a right of action against the licensor for breach of contract if you've built in provisions stating in the event the landlord sells the property, they must do X, Y, and Z. So accordingly, a license offers you no security in the event the landlord sells the property. If the license terminates, you have no right to enter onto the property to remove your equipment. Now, you'll recall earlier I said about a license is a grant to go onto a property and not considered a trespass. So if that license comes to an end, you would be trespassing if you went onto the property to remove your equipment. The landlord could get an injunction against you to stop you from doing so and stop you from reclaiming the equipment. A lease is a lot more difficult to terminate. If there are no break clauses in favour of the landlord or redevelopment clauses, then your 20-year term is pretty much fixed. The only time that would differ is what's called forfeiture, and that's if you as the tenant breach the terms of the lease and you continue to breach despite the fact the landlord's told you need to remedy it, they can follow the forfeiture proceedings and bring the lease to an end. And at that point, again, you have no right to remove your equipment, but there are many steps you need to go through to reach that point. Under the terms of a license, the license can be brought to an end at any time. Now, a license can be drafted to say they must give you X amount of notice, and you would need to build in enough notice in order to, put the scaffolding up and remove the equipment. So it's all of these considerations you need to think about when you're drafting the document. So, key considerations when deciding a lease or a license. Firstly, how many community groups avoid this and don't think about this is beyond me, but what does the landlord want? Ultimately, the landlord is going to dictate what document they want. So for all of the issues I've highlighted already, and I know it sounds obvious, but ask them. They may turn around and say, no, we definitely won't consider a license lease only. Or they may turn around and say, yeah, we'll do a license because it can avoid A, B, and C. I've been approached many times by community groups who have said, right, we'd like to set up a precedent document list, and we do all of that work only for them then to approach their respective landlords who say, we don't want a license. So please, please, please ask the landlord what they want. Number two, will the landlord agree to a buyout clause in the event it transfers the property? If they say no, then I would say you need a lease, because it needs to remain with the property. If they say yes, we will, if you can agree on what that compensation provision is, then a license, again, it becomes applicable. The lease has the benefit of having a restriction noted against the title. So anyone looking at the title will see that there's a lease and they take it subject to the lease. Whereas the license, with it being a personal contract, any incoming buyer of the property may be totally unaware that it exists. And so the landlord transfer it, and then your only recourse is going through the court system. Number three, are there any restrictions on the title which need to be dealt with? Well, I've already picked up on this. Bank consents may be required, Secretary of State consents may be required, and you'll need to have a look at the title to the property before making a decision as to whether a lease or license is applicable. So my top tip, and I know I'm going to say this because I'm the lawyer, but get a lawyer involved right at the outset. Unless you've got someone that's competent to have a little look through the title and say, oh, we've got this restriction, I've seen this one before. Or even if you've just got a lawyer or a friend that you can just phone up and say, can you grab me this title? It's £3. Can you tell me if there are any restrictions? That's a 5-minute job, and you will save yourself a lot of time and hassle in the future. Number four, are you borrowing any money or undertaking any share offers? If so, what are the legal requirements that you have to comply with? What protections do those investors want? What are you going to put in your share offer, and state what protections those investors have? My strong advice is, if you're ever going to go down the share offer route, you need a lease. A license isn't going to be sufficient. You really do need to protect the investor's income, and you don't want it coming back to bite you in the future if the landlord doesn't play ball, and then you've got all your investors upset because then their investment potentially has slipped away. Remembering that the lease is your investment, and that lease is registered against the title to the property, so it's secure. A license isn't. Now, moving on from that, you might not borrow money at the outset, but what if you refinance in the future? What if, let's say, you get a portfolio of 10 assets together and you think, look, if we refinance all of these, we can realize some more money and we can invest this again in new schemes. Well, if you've gone down the license route, I think you're going to have a problem. So it really does pay to have a little think about your setup and what you're looking to achieve, and what your goals are. Maybe not straight away, maybe not in a year, but 5 to 10 years, because remembering these are 20-year contracts. Number five, how quickly do you want to get the contracts in place? Now, given the removal of subsidies now, we are not driven by feed-in tariff deadlines and having to have a lease in place to make sure you've got the rights over the property. Query, is there a need to rush the legal process? And again, I would say this as a lawyer, but the amount of clients I have, whether they be developers, funders, community and community benefit societies, come to me and say, Justin, we need to get this done in a month. And I say, okay, well, what's the rationale behind this? Oh, we just need to get it. We need to secure the site. If you've got a good exclusivity agreement in place, that will secure your site for 12 months and won't allow the landlord to go and talk to anyone else about this project, or even do the project themselves if you've drafted the exclusivity agreement correctly. And an exclusivity agreement can be a page long. It need not even be that long. And I'll come on to an exclusivity agreement and heads of terms and how that helps shortly. So I would arguably say, don't rush the legals and get a lawyer engaged early on. They do a very little bit of work, and then you can go away and do all the legwork, do all of the agreeing the commercials, and then just get the lawyer to reflect it in the document. And there is a process to follow, and perhaps not one for today, but I can certainly share it with you another time. I've already picked up on point 6. If you propose to sell, borrow against the assets in the future, have you got the requisite document in place that funder is going to want to see. So Kate said she gave me some previous questions. Well, here they are, part 1 and part 2. I'll quickly whittle through them to ensure that we've got some chance for your additional questions. So is a license easier for a site to agree, and why? Yes, in the sense it's 16 pages long. Landlords often like them because they can terminate them quite easily, and they avoid the 1954 Act and perhaps some restrictions. In reality, I think they take just as long to agree as a lease, but that's my experience. Point 2, how easy can a landlord terminate the license, and can you remove your equipment? Well, this is the downside. It's far more easy to terminate a license. And although they are 20-year contracts, you do need to beef up the compensation provisions if you do go down the license route. Obviously, the downside of the license coming to an end, you've got no right to go onto the property to remove your equipment. So that's really, really important. How much does a license or a lease cost? And should I be paying the landlord's legal costs? Well, on the latter point, landlords often want their legal costs protected. You can understand they've got an asset and they want to make sure they're not tying themselves up in knots or granting anything they shouldn't be granting. And unfortunately, the way that legals are worded and drafted, things can be misinterpreted. And so I do see why landlords want that. And again, I'm biased because I'm a lawyer, I would be saying that. But if it were my house and I was granting a tenancy and I wasn't a lawyer, I'd be getting someone with the requisite experience to look at it. How much do they cost? It very much depends. If you've got a license, say for example, I just provided you my precedent license, I could say, look, here it is, 500 plus VAT, off you go, and you put it in place. Now, if you get into a negotiation exercise, it's on the time spent. So if you've got a landlord that's going to play hardball, you're going to rack up costs quite quickly. I would arguably say a lease is possibly more than a license, but it's all the incidentals that go with it, the title review, the search due diligence, the registration at the land registry, SDLT form if it's needed. So it's not just the lease, the license and the lease that you need to worry about. It's the wider due diligence that's required, and particularly if you've got funding involved. I'm more than happy to share pricing proposals that we do for our community groups, where you tend to offer a reduction. We do pro bono work, but because we've got, I would say, nearly 40 community groups on the books, our pro bono is well and truly exhausted at the moment. But we do it at a reduction. Generally, I would say to put in place a lease, you'll be looking at around about 2,500 plus VAT. And that's to do all the sort of title due diligence, etc. in behind. With a license, maybe a bit cheaper. You're looking maybe 2,000, maybe 1,750 plus VAT, being realistic. But it really does depend on the counterparty. If a landlord are going to be difficult, and you don't have your commercial terms agreed at the outset, then it's going to make it a longer transaction, which ultimately is more cost. So point 4, what's the benefit of having our lease noted at the land registry? Well, the whole world knows about it. So any incoming buyer that downloads a copy of the title from the land registry, which everyone can do, they will know that that property is subject to your lease. And so they take it subject to your lease. We often put a restriction on the title to the property that says the landowner cannot transfer the property without complying with A, B, and C. Now, A might be transferring the benefit of the power purchase agreement to the incoming owner to make sure you've got your income. Because Kate alluded to earlier, you've no longer got the lovely benefit of the government's feed-in tariff, that guaranteed subsidy. You are now reliant on the income from the power purchase agreement that the owner or occupier of that property pay you for the electricity generated. So here, have a little think about, what's their financial covenant? Are they going to be around for 20 years? Consider if they sell the property to a third party, do you want any control over who they might or may not, transfer the property to? Because they're then entering into that PPA and will be complying with its terms. I mean, it's a bit of a non-point, because if your electricity price is always 25% less than what the grid and the market supply, then it's always a benefit to them to have the PPA. But you'll be surprised at the arguments that arise as a result of, you know, the PPA and whether it transfers, should it not. Time taken to negotiate. How long's a piece of string? I've once negotiated a ground mount solar lease in a week, and it was put in place, and that was to hit a subsidy, and that was a 30-odd page document. I have also had one that's been going on for 18 months. In the community energy world, I'd say a rooftop solar lease generally, if you engage the landlord and the landlord solicitor early, can be sort of 2 to 3 months is my experience. And a license, I'm sorry to say, it's the same. But often you're dealing with, you know, the government, or you're dealing with local authorities, and it's notoriously slow. So yeah, it really does depend, and I'm sorry not to be able to give you absolute clarity on that. So part 2, if the landlord breaches the license, could we get compensation for cost of equipment, loss of earnings? Yeah, absolutely. We can build in whatever compensation provisions you want. A license, ultimately, it's a commercial agreement, just the same as a lease. So a lot will depend on, you know, the landlord and their financial covenant, and, you know, if they do breach, are they going to be in a position to pay you for such losses, and what are those losses? Is it the capex of the equipment, with any depreciation plus some compensation for the remaining term? And it's all of these terms that you must agree at the outset before getting a lawyer involved. Commercials, if you agree your commercial terms early, so length of the term, what compensation provisions, and what happens in the event of termination, what happens in the event they want to transfer the property, what happens to the power purchase agreement. If you can agree all of these things before a lawyer is involved, all a lawyer does is get a precedent document and just say, right, lease term 20 years, compensation needs to be A, B, and C. If the lawyer gets involved and has to then lead the negotiation of compensation, it's going to cost you a lot more money. Now, one thing you can do is piggyback, like Kate has alluded to, off of existing lease agreements that have been put in place and just roll them out. So if you instead just use a very balanced document as your starting point instead of a really biased tenant document, you're going to save yourself time and cost. We probably couldn't afford to fight a legal case, but will our insurers? What happens in practice? Truth is, I have no idea. I would be very surprised if an insurer would cover a community energy group in the event that they had a legal issue with their license or a lease. I doubt they would want to get involved. And insurance, at the end of the day, it's only as good as the small print. So you've got to read that carefully. Alternatively, and again, me being biased, why don't you just get some sound legal advice? It avoids the need for insurers and any increased premiums in the first place. So just make sure your documents cover all eventualities. A lease or a license is there to cover worst case scenario. So you shouldn't ever really have to look at it. You only get it out if there's an issue. Point 4, are there any implications on raising bank finance? Absolutely. I cannot stress it enough. You would need a lease. All of the institutional main lenders will want a lease because it's a registrable interest and they can register their own interest against your leasehold title. They can't in respect of a license. And finally, do you recommend any changes to documentation in view of the FIT changes? So absolutely, you know, we've been talking about 20-year lease terms because that was the length of the FIT. Now, why not make it 30 years if the landlord plays ball? That's spreading your risk. You know, if you have some poor years in the first 20 and, you know, final 10, that solar array is still going to be operational. Of course, it's going to have degraded somewhat, and hopefully it's, you know, still, you know, 80-85% efficient, but query the term. Secondly, the power purchase agreement becomes the fundamental document now because that's your income stream. So the terms on which that power purchase agreement is drafted is vitally important, and you need to make sure that if the property owner changes, that someone is always paying for that electricity. So it might be the case that the landlord gets a tenant in. Query, do you want that PPA moving to that tenant, or do you want it to remain with the landlord and then the landlord pass on the electricity costs? That would be my top tip. Make sure that's how it's structured. So there's lots of different ways of protecting your interest in the event the school, say, shuts down or closes. You could include provisions, for example, my commercial rooftop developers use something called a minimum supply offtake. So if the landowner doesn't use, say, 80% of the electricity and they only use 60, they pay a top up. Now, it's a difficult conversation to have with the landlord, to be saying, well, you're not using the property, but please can you pay me for what you're not used. But ultimately, they have to understand you're putting in place an asset that's going to be there for 20, 30 years, and it's going to cost you 20, 30, 50, 100 grand. So you need to protect that asset. So if you can reach some agreement there, it's really going to help. So I'll quickly whistle through. Heads of terms / exclusivity agreement. Sorry, it isn't on there. Absolutely vital. I cannot stress it enough. That is the best way to reduce your legal costs, get all of the terms agreed at the outset, and it will streamline the process. Option agreements, arguably for any sort of rooftop solar, I wouldn't suggest you need it. And that's where a license is better. As Kate alluded to, you can enter into a license straight away and it protects your interest. But if you've got an exclusivity agreement, they can't go entering into other negotiations with a third party anyway. What an option agreement does, however, do is make the landlord grant you the lease. They cannot back out. And the same if they've entered into a license, well, unless they comply with the termination provisions, again, they can't back out. Bankability, well, that kind of leads into due diligence. Make sure you're doing your title reviews. And I explained to Helen and Kate yesterday, community group approached me, said, Justin, we've undertaken a solar project on a roof. We'd like to register it at the land registry. So I download the title, have a look. There's a restrictive covenant from Devon County Council saying no electricity generation on the property. Who'd have thought? 10 years I've been doing this, I've never seen that. We had to apply to the council to remove the restrictive covenant. They ended up spending over £2 grand of additional costs because they didn't do their title review and due diligence at the outset. So had they done that at the outset, they might have turned around and said, actually, that's not one for us. So have a think about searches as well. Maybe a local authority search and a search of the index map as a sort of minimum. Environmental and drainage and water and utilities a bit overkill for a rooftop. And then consider indemnity insurance to cover risk. So if, as a result of doing any due diligence, there are issues that have arisen, then you're going to need an indemnity insurance policy to cover those risks. If you enter into the transaction and then an issue arises, you won't be able to get indemnity insurance. So I'm sorry, that's a really whistle top tour of leases and licenses, and I'm happy to answer any questions.
So one question's come through. Can we do legal searches ourselves, or do we need a lawyer?
No, absolutely. So the two searches I referred to as a minimum, I would suggest, for particularly, I'm talking rooftop solar here. If you're doing wind or hydro, then I would suggest additional. But you can approach the local authority direct in order to obtain a local authority search. It costs around about £170 to £180, depending upon which local authority. It takes about 2 weeks to come back to you. A search of the index map you can obtain from Her Majesty's Land Registry online portal. So just set yourself up as a user. And you just need to upload a plan and they come back to you and they will tell you which title numbers are applicable to that property and whether it's registered or unregistered. So yes, by all means, you can do it yourself.
So we had a couple of questions right at the start, which was around the costs and the challenges. I hope that they've been answered, but if they haven't, please come back and say if you want any further clarification. And then the next question is, have you got any experience of setting up leases for social housing projects where the installations might span several properties with a common landlord, or where some properties are available for shared ownership? And does this present any issues with mortgage lenders for buyers or the housing association borrowing their assets in the future? There's quite a few questions there, but you're nodding your head, so hopefully you can cover
Yeah.
it.
Sure. So yes, definitely on the social housing and across multiple assets. The one thing I would say here is you need to make sure your lease is CML compliant, Council of Mortgage Lenders compliant. If you go on the CML website there and look for solar panel leases, there is a letter which sets out the terms upon which they are expecting to see. So one thing I didn't cover and I wanted to was grace periods for removal of roof solar arrays for roof repairs. And this is a big issue that comes up all the time, and what should or it shouldn't be. The CML handbook sets out what the minimum requirements are for sort of residential properties, which would include social housing. And it's a bit of a moot point. And again, it's something that should be agreed at the outset in your heads of terms. Generally, it's, a couple of weeks during a 20-year term, maybe once or twice. But if you've had a technical survey of the roof space and they've said, look, the roof's great, it's going to be there for 20 years, won't need any repairs, you're not going to have too much of a concern in including a grace period in your lease or license. So, you can take a view, and it can appease people. Going back to the social housing point, with regard to borrowing, we have set up schemes. I'd say more on a heat for district heat system being used a fair. Some ringing, which we have done a fair amount of work in, and it has required sort of institutional lenders who have got comfortable with the lease and it being over various parts of the site. And I think the same would apply in respect of rooftop solar. In Bristol, which had a communal kitchen area, and then people had their own living units. Which had a rooftop solar array and a battery, and it was all interconnected with one landlord. So yeah, that's it's more difficult to put in place, but from the point of view, from a legal point of view, it's relatively straightforward. So yes, that can most certainly be done.
Okay, thank you very much. So the next question is. Just bear with me a second. So you mentioned the downside to one of the downsides of a license is that there's no right to access the property on termination. I think you also mentioned that you can build in a notice period before termination. Can you include a right to access the property in that notice period? Is that basically the point of the notice period? Is it overcomes that issue with the lack of access after termination?
Yeah, absolutely. I mean, the one thing you want as the licensee of the property is notice. You're going to want to know when that termination is, so that you can get your ducks in a row in order to get people on to remove the installation from the property. That is the purpose of that notice period, and if you don't have that notice period in there, it becomes a bit of an issue. Now, if, let's say, for example, the landlord just simply terminates the notice in breach and they want you off straight away, a license can be brought to an end in that manner, but you could then seek specific performance of the contract, and so they then get a court order to give you the ability to go on and remove the array. The reality is, I've got no experience of this because I've not, touch wood, had any instances where we've put in place community energy schemes and there's been a need for something to be terminated. So this is ultimately all new. So yes, the notice period is vital in your license, and again, something which should be agreed at the outset in your heads of terms.
Thank you very much. Thank you for everyone who's included the poll, answered the poll so far. But if anybody who hasn't could do it. Just a quick reminder, it's still open. Kate's going to come back and join us in a minute, but in the meantime, David Kemp has made a further comment on his point, which I'm not quite sure I fully understand. David, do you want to actually say anything in person, or have you got any further questions you want to ask? Hi, David.
Yeah, no, so in relation, well, it's more of a question. So you talked, Justin, about compensation under a license, and you could effectively require the current owner or licensor, I never can tell which way around it is, apologies, the person you've got the license with, they can, effectively ensure that the new purchaser of the building takes on the power purchase agreement. Does that new building owner, they might say, yes, we'll enter into the PPA with you, but once they're in the building, say, actually get your kit off my roof, you ain't got a license with me. Can they still do that?
Yeah, I mean, and so that's part of it very much depends on the wording of the license. So if the license were to include a provision that says, in the event the licensor wants to sell their property, they must procure, so obtain from the new owner a license on the same terms for the duration of the license. But that's only as good as the landlord actually, or the licensor, I should say, doing it. If they don't do it, then you're back in the compensation provisions again. Okay. So that's where you were building an indemnity, which basically said, in the event the licensor hasn't transferred this license to the new owner, you indemnify us for all of our losses, or as prospective losses, ultimately, up to and that you would potentially put in some liability caps.
Okay. Cool, thank you.
No problem.
So does that answer your question?
It does, it makes it crystal, thank you.
Good, I'm very pleased. Just whilst anybody else is thinking whether they've got any final questions, Kate, do you want to come back and make a few final comments?
Yeah, I just wanted to say thanks to Justin, because I agree with what Richard Lane said in the chat. Brilliant, really clear and helpful explanation of. It's much clearer in my head now. I think there's, we've still got to make a risk-based decision, but to be able to understand what those risks are is really good. So yeah, thank you for your time.
I think I'm sorry to say, but I think the risks have increased since the feed-in tariff has disappeared. So, previously in a power purchase agreement, we might put a provision in that says you can keep the equipment on the property in the event the lease terminates and continue to export and continue to receive the feed-in tariff income. Whereas now you're solely reliant on the power being purchased by the owner of the property or the occupier, whoever's in there. So that's where one of the questions was, would we expect to see any changes to the fit lease or fit license? And yes, I think it needs to be bolstered because the risk profile has changed. So it's definitely something to have a look at. If you're going to roll out your existing leases and licenses, just have a little think about the knock-on effect of the fact that there's no feed-in tariff. And just make sure you're covering yourself as much as possible. And all of any agreement between A and B, there's risks involved on behalf of both, but ultimately there's more of a risk that sits with you, as you're going to be putting the investment into the property and looking to recoup that investment over X amount of years.
Yeah, I think it's brought to my attention that we need to look again at the PPA, and also that we normally sign it with the school, and if that we should have a conversation with the council about it. Something that the first thing that came to my mind when the feed-in tariff went was that in the past, when we've negotiated a lease, the landlord has said, well, say we want to do something with this building, could we move it to that building? And we've said, no, we need it to be plugged into that specific MPAN because that's linked to our feed-in tariff. And I thought, oh, now that's not a problem. Actually, if they wanted to move it, maybe that's something we could agree to. But it sounds actually like we need to be equally sort of standing firm in our position.
Yeah, so I've got a commercial client that so this I made reference to it earlier about bargaining power. So I've got a commercial rooftop solar developer They have about 2 megawatts of assets now, so you know, a fair amount. But they were approaching a big institutional property owner to do a portfolio of rooftop assets. And when we're getting down to the nitty-gritty of the compensation provisions, the property owner said, well, I know what you can do. Just if I want to redevelop this property, just put it on one of our other properties. And we say, well, okay, that sounds all good in practice, but who's going to pay the cost of moving it? Who's going to pay the cost of compensation whilst it's down? What if the roof isn't fit for purpose? What if the roof doesn't have the same solar radiation because of its degree of angle? What if you redevelop that property and you don't have another property? It creates a cascade of what ifs. And so in theory, it's a great idea. But let me say the legal drafting becomes very complicated.
It sounds it. Thank you.
Right, I think that brings us to the end of the question and answer session, and just remains for me to say thank you again very much to both of our speakers today. You've both provided an excellent overview and insight into your areas of expertise, and it's been a very useful process. I hope everybody has enjoyed it. The feedback is certainly looking good. We'll be sharing the slides and a recording of the webinar, and this last slide here just shows how to keep up to date with our future events, our future activities, and just what we're doing in general to work with the community and local energy sector. And if anybody wants to get in touch to talk about their projects, we're always more than happy to talk about them at an early stage. I'm also going to stay on here for about 5 minutes just in case anybody fancies a chat now, but otherwise that's the end of the session. So thank you very much for everybody for signing in, and again to our speakers, and hopefully we will all see each other again soon.
Thanks very much.
Thanks, Justin.
Bye now.
Bye.